For the opportunity to contribute today in this debate. Madam President, before us today is a bill which seeks to extend the life of an act that was passed in 2019. And it is important for us to understand exactly what the 2019 law was meant to accomplish and the ramifications of that 2019 law in real and meaningful terms if we are to understand why it is, and if the population particularly is to understand why it is we will not support this measure. Madam President, the 2019 law, which has been in effect for 3 years, coming up on 3 years, does not, contrary to the narrative that is being created, does not just target repeat offenders. In order to be a repeat offender, you have to be first convicted of an offense. And then you repeat and you come out of prison and you commit another offense. But this bill that was passed in 2019 goes beyond that. There is one section, the first part of the provision, deals with a person charged with an offense under Part 2 of the first schedule who has been previously convicted. But under Section 5.3, Madam President, a person who has a pending charge and is again brought before the court on another charge, an accusation, will automatically be denied bail for 120 days, which I understand some people in listening to the debate before didn't think that was very long. Well, I spent about half an hour in a prison cell in Remand Yard once upon a time on a visit. And that was the longest half an hour of my life. And to this Parliament to stand here today in the context, and I will get into the context because a lot of time has been spent talking about the context and the situation that we are in right now as a country. But in the context of where we are, having had this law in place for 3 years, to put someone in prison on an accusation, whether it is 1 or 2 accusations against them, having that person never having their day in court to mount a defense is unconscionable. It is unjustifiable, and I dare say it is unconstitutional and illegal, and I will get to that, and why judicial developments have to be taken into account with this bill today. Madam President, the law as it stands today on the 6th of July in this country is that any attempt by the legislature to interfere in the grant of bail by the judiciary is illegal, unconstitutional, and a violation of the separation of powers. And I cannot understand how, in light of what has happened in the course of our judicial development since 2019 to now, the government could be asking us as a parliament to join hands with them and pass an illegal law. They are asking us to come here and work with them to pass a law that is liable to be struck down. Madam President, it does not matter where there is an appeal or what is an appeal. There is a ruling that is the law of the land, the doctrine of stare decisis that you learn on the first day that you enter your LLB program says that unless a ruling is overturned, it is the law of the land and we must abide by it. And the law of the land right now is that it is not reasonably justifiable in a country with due respect for the rights and freedoms of individuals for Parliament to legislate away what is a core judicial function. What the attempt by the government here today, by bringing this bill, they are trying to camouflage their abject failure in dealing with the crime situation. And not just Not just the crime situation alone, because it is not just on crime that they have failed, and several of my colleagues have gone through the trouble of identifying how other failures are contributing to the rise in crime. They are failing in education. They are failing in the management of the economy. And all of these things contribute to the rise in crime. So as they fail on this side and they fail on that side, they come to ask us now to pass an unconstitutional piece of legislation. Because I don't know, apparently passing law now is like a make-work program for attorneys who will get briefs from the state, because this will be challenged, and I dare say, and God so help me, I will be part of the challenge to this piece of law if it is passed today. And it will be struck down. Because in light of everything, I don't know if anyone who has come here in support of this piece of legislation today has read and has followed the development of the law from 2019 to now. And with the greatest of respect to Senator Richards, he asked, what has changed in the part of the opposition? What has changed is that the court has ruled on the issue of bail being a judicial function, and it is not Parliament's place to interfere with it. So what the government should have been doing, instead of having us here for 2 days talking about the state of crime in this country, because that is all I have heard from the government bench, and I follow the debate very closely. That is all I have heard from the government bench, how bad crime is in this country. What they should have been doing is looking for alternatives to dealing with crime, not coming here to just revamp the same thing that has not worked for the last 3 years, which has now been deemed unconstitutional by the court. That, Madam President, represents an admission of failure. It represents intellectual bankruptcy, and I think that the government have simply, they are just simply ready to give up if this is the only thing that they can really bring to this Parliament and to the country to say that they are dealing with the crime situation. So, Madam President, the government's solution is that once a person is accused by the police of committing a certain list of offenses, any of those offenses, you must throw them in the prison and lock them away. It is like out of sight, out of mind, and that is supposed to give the population some kind of comfort. That is supposed to give the population comfort that the government is prepared to ride roughshod over the constitutional rights guaranteed to every citizen of this country to say that it is a mechanism to treat with crime. And the judiciary is replete with judgments that anybody is free to go and research and read that says that the core function of bail is not as a crime-fighting tool. It is meant to secure attendance to court. It is meant for the protection of witnesses where a threat exists. It is meant to ensure that that persons do not reoffend if it is that they are susceptible to doing so. And the point that no one is grasping is that all of the objectives that the government say they need to achieve by this bill are things that judicial officers are empowered to and mandated to deal with by Section 6 of the Bail Act. Section 6 lists all of the criteria that the judicial officer must take into account if they are going to grant bail. And that includes the risk of reoffending. It includes whether or not a witness will be threatened. So the judicial officer, on the first occasion that a person is arrested and brought before them, has the opportunity to offer the country and the citizens, and as I heard repeated over and over, the young men and the young women and the elderly and everybody else, or the government trying to be emotive about this matter, the judicial officer has every opportunity to offer protection where it is warranted. And I do not understand why the government feels it is their role or the role of this Parliament to remove that opportunity from the judicial officer. There is absolutely no evidence presented by anybody on the government bench to say that we have had irresponsible judicial officers granting bail to persons. None. None whatsoever. And it is really an affront to our democracy. It is an affront to the basic concept of separation of powers enshrined in our Constitution that the government will, in light of what has been said by the courts in this country about separation of powers and what is a judicial function and what is the role of the judiciary as opposed to the legislature, that they would ask us to pass this bill here today. Madam President, the purpose of a sunset clause, as was included in the 2019 bill, is so that you can assess the efficacy of the bill. And I think that the editorial in today's Express, I could have just read this as my entire contribution because it is so on point and it is so accurate, because it speaks about the very serious concession given to the government in 2019. The parliament sat here and agreed. The opposition gave you the opportunity. You say you need a tool. You need tools to fight crime. You have had the tools for 3 years. And what do they say has happened? And I want to quote from that editorial, today's editorial, 6th of July, 2022, in the Trinidad Express, page 12. Neither the government nor the police seem to appreciate the huge constitutional concession made by the Parliament in agreeing to deny bail for 120 days to persons charged with certain offences while the police build a case against them. In agreeing to this draconian steps 3 years ago, the Parliament accepted the government's argument that this constitutional ammunition was necessary for bringing rising serious crime under control. It goes on, the fact that gang warfare and killings are today out of control is tangible evidence of the failure of the Bail Amendment Act 2019 to deliver on its promises. So, Madam President, the entire country, I read an article by quoting former Attorney General Ramesh Lawrence Maharaj, distinguished senior counsel, saying this is not the way to go. I read this editorial this morning. It is not the way to go. I read comments from criminologists from the university asking where is the evidence that this bill is working. And in listening to the contribution of members opposite, I heard the minister in the Ministry of the Attorney General spend some time on statistics. Oh, Madam President, I think that between the Honorable Minister and the Attorney General himself, they have made our case for us here today. The Attorney General, firstly, when he talks about the tests and what must be done here today, he quoted the Dominic Suraj judgment which confirmed the case of Surat and the approach to be taken. It says that we must ask ourselves today whether the bill strikes an acceptable balance between the rights and freedoms of the individual and the community at large, and that is true. How do you, otherwise the act is liable to be struck down, even if it passes with the 3/5 majority, which I really do hope, and I urge all members not to give a majority on this bill today. And I will tell you why. Apart from it being unconstitutional, Madam President, we have to look at what it has accomplished. And in dealing with the statistics, apart from admitting that the state of crime today that we live in Trinidad and Tobago is frightening, and it is serious, and that today we have absolutely no control over what is happening in this country, they have missed the point entirely. That for the last 3 years, having these powers, nothing has been accomplished. So all of those things have to be taken into the mix when you are weighing the proportionality of this measure. What has it accomplished? Nothing. And let me talk to you about a little bit about the statistics. This bill was passed in 2019, so middle to, or somewhere August 2019, so halfway through the year or more than halfway through. So let's forget 2019. The same statistics quoted by the minister, I don't know if where the minister in the Ministry of the Attorney General got her statistics. I got mine from the CAPA Crime and Problem Analysis Unit website of the TTPS, which is there for everybody to check. Murders in 2020, let us do a comparison from 2020 and 2021. 2 full years when these provisions that they are seeking to extend today were in effect. The police had the tools, as they call it, that they claim to need to bring crime under control, and add to that in the mix that we had a state of emergency that restricted people's movements and so on. sometime during that period, in different times. Murders went from 393 to 448. Now, every time the minister quoted a statistic, I noticed she paused to say, we're not where we want to be, We're not where we want to be. Madam President, it's not that we are not where we want to be. We are worse off. We are worse off than where we were. We are heading towards 600 murders for this year with this law in place. I noticed that people stay away from percentages. Now, I know lawyers aren't very good at math, but there's an app for that. We had a 13% increase in murders from 2020 to 2021 while this law was in effect. Woundings and shootings, that is how it is classified by CAPA. Woundings and shootings went from 401 to 610. Everybody and their grandmother. I literally read an article by one of the young men shot over the weekend. His mother is saying she's appealing for them to deal with the guns coming in the country. Even a mere civilian who has lost their child could have the coherent thought to identify the problem as being guns coming into the country, but the government is coming here to tell us about bail when they are doing nothing to arrest the situation of guns coming into the country. And when we look at woundings and shootings, you have a 52% increase in the numbers from 2020 to 2021, and they come to tell us today that crime is down, and this is a tool that the TTPS needs, and therefore we must extend it. And when you look at the detection rates in simple numbers, it's very easy to use statistics to fool people, because the Honorable Minister is saying, well, 111, well, I don't know, I can't remember the statistics she quoted, but if you look at it, yes, 111 detections for woundings and shootings in 2020, and that went up to 132 in 2021. But, Madam President, if you look at it in percentages, according to the amount of crime you have, you went from a detection rate of 27% in 2020 to a detection rate of 21% in 2021. So while crime and the incidence of crime rising, the detection rate by the TTPS is actually falling. And that is the basis upon which the government comes here today to tell us that they need this piece of legislation to fight crime. When for 2 whole years, January to December 2020 and January to December 2021, with this law being in effect, these are the results. Sexual offenses, rape and serious indecency went from 386 to 382. So that went down slightly. Larceny went from 1,283 to 1,500, Madam President, a 16% increase. And these are some of the offenses that we are saying if a person is accused of on 2 occasions by the police, without ever having their day in court, we must throw them into remand yard for 120 days. And up to a year if the prosecution come and release one witness to say, yes, I was there and this is the person and I arrested the man. That is all it takes, That is all it takes for the prosecution to start its case. It could call one witness, and the case has started, and a person who is supposed to enjoy the presumption of innocence will be remanded into remand yard, which judicial officers in this country have written judgments describing as a hellhole. And we will put someone in there for 1 year on the mere say-so of the police without a judicial officer ever hearing one scrap of evidence. Tell me how that is reasonably justified in a society where crime is rising and detection is falling when the law is in effect. Explain that to me and to the population, Madam President. That is what the government must do here today. And that is what they have spent an entire day here. Some 20 persons have spoken, and not a single person on the government bench can show us how it has helped. What would have helped? And perhaps in his winding up, the Attorney General can tell us how many of the persons denied bail in the last 3 years, when they were arrested, have the government recovered firearms and taken firearms off the streets? How many of those persons denied bail for 120 days or up to a year have actually been convicted of any criminal offense to date? A man could have been arrested in 2019 and spent 3 months in prison. And as of today, he is still in the eyes of the law, innocent. Or he could have spent a whole year in prison because his case has started. But in the eyes of the law, he is still innocent. This attempt to remove the judicial discretion to grant bail and to automatically deny bail to persons who have never been convicted of an offense makes a mockery of the presumption of innocence. And the presumption of innocence is a cornerstone in the foundation of our criminal justice system. If we lose the presumption of innocence, Madam President, we might as well just take our entire constitution and throw it in the dustbin. It is disrespectful to the constitution of this country for us to pass a law that makes such a mockery out of the presumption of innocence. It makes a mockery of our democracy to say that on the mere say-so of a police officer who says that a firearm was involved in a matter, in an alleged crime, allegedly committed by someone before the court, that they must be denied bail. That is basically saying that we have no belief, none whatsoever, in our judiciary. It is saying that we have no respect for the rule of law. It is saying that we have no respect for the rights of persons to make a case before a judicial officer. And I don't know about anybody else, but I am not prepared to stand here and say those things. And the opposition is not prepared. In 2019, they lobbied very hard against the opposition. And the government has a tendency, every time there is a spate of crime, to blame it on the opposition's lack of support for legislation. So in 2019, we gave it to them. We gave them the opportunity, and they have absolutely nothing to show for it today. Not one single accomplishment. When we are getting back to the process of weighing the proportionality of these measures, Madam President, it is quite simply inescapable for us. You cannot avoid asking yourself what else could be done. What else could be done, and what other options are available other than taking away people's rights or deferring them, as I heard one member opposite say, because apparently that seems more acceptable. That I could take away your rights today for 3 months and that's okay, but I'm not taking it away, just for 3 months. I want to know if it is that you could say to somebody, well, I will take away your property for 3 months.
Senator Naked, you made a comment earlier, I ignored it. Please stop it, all right?
Yes, thank you, Madam President. If you are taking away someone's property today, can you tell them, well, don't worry, I will just take it for 3 months and that's okay? But you are taking away someone's liberty for 3 months. And when you are looking at the proportionality of that measure, apart from its success for the last 3 years, we have to consider the conditions in remand yard. Madam President, this government has brought evidence of the cost of keeping someone on remand yard. And when I went back into the archives and I recalled that it was the Honorable Attorney General talking about the 60% of the prison population being on remand and $20,000 to $25,000 a month to maintain someone at remand yard. You know what it triggered in my mind? It triggered in my mind a memory of an affidavit filed in a matter before the court, which was already heard, an application for a stay on the grant of bail. And the head of the electronic monitoring unit in this country said that they were unable to fix electronic monitoring devices on all the persons who are eligible for bail as a result of the court judgment because they didn't have enough devices. And a device cost $12,000. One prisoner, and that is a matter of public record, anybody could go and check it. That is the affidavit evidence that the state put in. So one prisoner in remand yard for a month could purchase 2 electronic monitoring bracelets. And that not only frees up the space in the remand yard to keep persons who actually pose a threat to society and who a judicial officer determines ought to be placed there, but it also creates a number of opportunities, Madam President, to preserve the social fabric of a person's life who is innocent in the eyes of the law. Persons here, I don't know how many people here have ever interacted with someone charged with a criminal offense, but I feel it is my duty, having sat on both sides as a prosecutor and a defense attorney, to put the facts, the raw, simple facts before this court. That when a person is denied bail, what happens to them? If they are kept in prison for 3 months or 1 month or 2 weeks, and they cannot pay their rent, they are thrown out of where they live. Their relationships, familial bonds break down. I remember one time a man in tears. He was a repeat offender. And that's okay. Every sinner has a future. Every saint has a past. He was a repeat offender. Yes. And I sat there and I listened to him and I said, well, you are charged again with robbing someone. Why? Why are you here again? Why would you do something like this? And he said to me, I was denied bail. I spent my 3 months until I was eligible to bail. Even after that, I had problems accessing bail because of the amount, but eventually I came out. By the time I came out of remand yard, my wife left me, but she put me in court for maintenance. There's a court order saying that I must maintain my children. My employer fired me because I was missing in action for 3 months. So the little job that I was able to hold down before and earn an income, I was not getting it anymore. I have to live. What do you expect me to do? You see, our prison system is inextricably linked to the issue of bail. And the absence of any sort of rehabilitation or any sort of program to manage offenders is why the restriction on bail is so disproportionate. Because what you are doing is you are going to take people off the street who supposedly enjoy the presumption of innocence, keep them in the prison for 3 months, and then unleash them onto the population where they are unemployable, having spent 3 months inside the prison, lose all manner of support that they may have had before being arrested. When a person is arrested and they are brought before the court and they eventually are granted bail, provided that they can access the bail and they have a bailer, they are able to go back into life within a week maximum, let's say. But when you keep someone in prison for 3 months and then they are allowed to come back out, because we all know the chances of starting a case in 3 months' time is slim to none, or 4 months. So what happens when you put them back out there? You are putting them back on the pathway to crime. And again, Senator Richards asked about what has changed. Well, Senator Richards sits on the same Joint Select Committee that I sit on. And at a public hearing dealing with the prison system and gangs in Trinidad and Tobago, we heard evidence, and it was widely reported in the media, that the prison is the place where gang recruitment takes place. And persons appearing before that committee said that special attention should be placed to remand. So when you decide now that a person who might be in problems with the law, never convicted, but in trouble with the law for a second occasion, must go into remand yard and must stay there for 3 months, what you might actually be doing is putting them directly into the feeding ground of the gangs in Trinidad and Tobago. Gang recruitment happens more in remand prison in this country than outside of the prison, and that is a fact. So when we are looking at the proportionality of this bill and the government's move to arrest the crime situation, the government is taking someone who might be an undergraduate in crime and getting them after 120 days to come out with a PhD in crime as a seasoned gang member and unleashing them back on the population. I don't understand how, with all of the evidence, anecdotal, Joint Select Committee, media, and what every man, woman, and even some children on the street know and understand to be the circumstances that exist in the prisons in Trinidad and Tobago, this government could actually convince themselves, because I don't think they've convinced anybody else, but convince themselves that this law has any merit in it whatsoever and can accomplish anything. This law is simply a failure It is an utter failure. Madam President, the fact of the matter remains that our Constitution grants people not a right to bail, but a right to apply for bail. The courts are perfectly capable of protecting the public interest. Those are the words of the Chief Justice in rendering his decision on a matter involving the constitutionality of bail restrictions. The removal of that discretion, Madam President, from the judiciary is not a solution to crime. And we stand here week after week, month after month, every single time a piece of legislation is brought to this parliament dealing with any aspect of crime, and we give the government proposals, we talk about the solutions, and it is their fault, and it is as a result of their implementation deficit that we have no DNA testing, we have no progress on forensic matters, we have no electronic monitoring, we have no parole system that they have promised us. And that is why crime is out of control. We have very little border control to intercept the influx of firearms, and that is why crime is out of control. It is not because people are getting bail, because people have not been getting bail for the last 3 years, and they have absolutely no evidence to show us that this has made an impact in this country, Madam President. We have gone from bad to worse, and I will not participate in something that is not only a failure, but it is illegal, it is unconstitutional, it is doomed to fail if it goes before the court, and it will go before the court if it passes. I give them that assurance on behalf of the opposition of this country. I give them the assurance that if this bill is passed and it becomes law, it will be challenged before the courts in this country. And I am well placed to give that assurance. I do not understand how a government that has failed to implement any meaningful measure to address recidivism and repeat offenders by having a system in place to manage people when they exit the prison system can actually think that denying bail to persons when they are charged is a solution to crime. I cannot understand how a government faced right now with an education crisis where children are simply without opportunities in this country could think that restricting bail and throwing them in a prison where we just don't have to deal with them. Like I say, it is out of sight, out of mind. It is the equivalent to, I don't know if you recall when we were having, I don't know if it was the Summit of the Americas or CHOGM, that they built a wall.
Senator Lutchmedial, just 1 second.
I think it's going a little wide.
Senator Lutchmedial, continue.
Thank you, Madam President. Madam President, you see, going wide and dealing with the government's failure on crime is essential because it is the government's failure on crime and the failure to deliver on every single promise that they have made in the economy, education, crime, everything else. That is why we have an out-of-crime situation that they are attempting to remedy by throwing people into remand yard. And yes, as I was saying, it is the equivalent of when they built a wall along the highway when President Obama was visiting. It's like you could just block it out. We don't have to look at it. That is the equivalent of what they are trying to do now. They are trying to block out, and we don't have to deal with these prisoners because, listen, the law is there to throw them into remand yard. And that is the solution that they want to come with here today and tell us that that is the solution to crime. Madam President, when you look at proportionality, and very quickly, I just want to deal with this. If you have to deal with proportionality, could you just let me know how much more time I have?
You have 7 more minutes.
Thank you, Madam President. That is enough for me to go through some of the judgments, none of them under appeal, because I know that if I say anything about judgments which are under appeal, they will jump up erroneously on the sub judice rule. But I will deal with judgments that have dealt with prison conditions in this country, Madam President, because it is absolutely necessary when weighing the proportionality of a bill that will put someone who has the presumption of innocence into remand yard to understand what that means for an individual, what they are going to be subjected to for the 120 days at the behest of this government. I refer to the case of Colin Edgehill and the Attorney General in 2008, Madam President, where the Honorable Justice Gobin quoted extensively from other pieces from studies and so on in the prison. And the Honorable Judge stated, and I quote, "The remand yard, Port of Spain, is a hellhole in which a man presumed innocent is deprived of the elements necessary for human life: air, light, sanitation, hygiene, exercise, and even food. The level of pain and suffering inflicted during detention goes beyond the harsh, or what is, to my mind, can conveniently be described as mere unacceptable and unsatisfactory. The treatment makes a mockery of the presumption of innocence." Madam President, the government are asking us today to pass a law where an innocent person could be subjected to those conditions. In the Privy Council judgment of Terence Calix versus the Attorney General, Madam President, they describe the prison conditions at the Golden Grove prison. And they talk about the Inter-American Court of Human Rights report into detention.
Senator Lutchmedial, you have 5 more minutes.
Madam President, cells of dimensions of approximately 9 feet by 6 feet are shared by up to 7 or 8 prisoners. Sleeping facilities are inadequate with only 1 double bunk in each cell. Consequently, many inmates are forced to sleep on the floor on a thin piece of worn carpet which is never cleaned, or on a thin sheet if provided by relatives. Cells are poorly ventilated, are hot and uncomfortable. Lights may be kept on all night. A single plastic pail. I don't know if everybody here has ever understood the concept of a slop pail, but that is what you have in remand yard. A single plastic pail is provided for use as a toilet by all the detainees in the cell. Madam President, the government is here today to tell us that any person on the mere say-so of a police officer, a person who never has the opportunity to mount a defense to an accusation against him, a person never convicted of an offense but accused on 2 occasions of a crime by the police, who have absolutely never presented any evidence before a judicial officer, will be subjected to those conditions for 120 days. And that is what this government thinks is the solution to crime. That is a solution to psychologically create a criminal. That, what the government is proposing here, is what will force people to come out of there in 120 days and be angry at the world. Madam President, I have spoken in this parliament before when I was a prosecutor of making several applications for someone to be denied bail for a sexual offense, on the ground that they were, because they had the age of the victim and so on. And do you know that after some 7 years of that person being in prison, the victim admitted to lying? The victim was trying to hide a relationship with someone else by whom she had become pregnant, and pinned it on someone who had given her a drop home. On those simple accusations. And you know why I call them simple accusations? Because the criminal justice system and prosecutions in Trinidad and Tobago are still reliant on the say-so of witnesses who are inherently, in some cases, unreliable. Human beings are not scientific evidence. So when a person spends 120 days or up to a year in prison, by the time their case comes before a jury, in 5 years or 10 years, witnesses could recant. And the witness could say, look, I lied. And what happens then? You have taken away a person's life. The matter that nobody wants to talk about, where the Bail Act was found to be in violation of separation of powers. A man was deprived of his life for 9 years under these conditions that I have described. 9 years, Madam President. And what did it accomplish? Absolutely nothing. And in winding up, I want to say, I heard a member opposite say that the 120 days in certain cases could afford the police the opportunity to investigate. Madam President, if the government thinks that the answer to crime is to make police inefficiency permissible, well, they are severely misguided, and we cannot, on any circumstances, condone that. And I want to strongly condemn any suggestion that a person should be charged and brought before the court in Trinidad and Tobago and remanded into custody while the police go about collecting evidence. You are supposed to collect and have sufficient evidence before you charge someone. And if we had a working criminal justice system where you could go before the magistrate on the first occasion and say, we have retrieved fingerprints that links this person to the crime. We have DNA evidence linking this rapist to this particular victim. We have in our possession CCTV camera footage that places the person on the scene of the crime, committing the crime, the judge or the magistrate would deny bail because it is the strength of the evidence. And people who have never appeared in a court and who have never heard a bail application made do not understand that the first inquiry a magistrate will make is about the status of the victim and the evidence that the police have against the offender. And if the police and the prosecution were given the resources to be able to do that, we would not need this piece of legislation, Madam President. So this plaster is meant to hide and it is meant to cover the gaping wound created by the government's failure to address every single aspect of the criminal justice system. And Madam President, for those reasons, we will not support this bill and the extension of these draconian measures. I thank you.
Minister of National Security.